The courtroom fell silent on a November morning in 2023, 43 men and women seated in rows behind a young attorney who had spent 3 years being called obsessive, paranoid, and worse. Sarah Chen sat with her hands folded over a filing cabinet that had been mocked as the work of a hoarder. The cabinet now bore an evidence tag. Federal marshals stood at parade rest along the gallery walls. In the third row, Margaret Chen, senior partner, architect of corporate mergers, mother, wept silently into her hands. On the bench, Judge Rebecca Thornton held a single photograph, its edges worn from handling. The image showed a witness statement that no longer existed in any government database, a statement that had saved a man's life. The prosecutor who had altered that statement was already in custody. The digital system that had promised permanence had delivered catastrophe. And the woman everyone had dismissed as a disgrace had become the only memory the justice system had left. But 3 years earlier, Sarah Chen had been nobody's savior. She was 25, newly barred, walking into the federal courthouse with a camera bag slung across her shoulder and a leather binder tucked under one arm. Her mother had refused to attend the swearing-in ceremony. Public defense, Margaret had said, was poverty law at clerical work dressed up as advocacy, a waste of a legal mind. Sarah had chosen it anyway, apprenticed herself to Thomas Wade, a 64-year-old defender whose office smelled of coffee grounds and old paper. Wade kept 3 filing cabinets behind his desk, each drawer stuffed with photocopied case files going back 2 decades. He told Sarah the same thing every morning: the system forgets. You must remember. She thought it was philosophy. He meant it as prophecy. Wade taught her to photograph everything, every page of every file, every exhibit, every witness statement before it went into the record. He showed her how to cross-reference digital entries against physical originals, how to catalog by case number and prosecutor and judge. When Wade died of a heart attack at his desk 6 months into her tenure, Sarah inherited his camera and his suspicion. She kept photographing. Colleagues thought it strange. Her supervising attorney called it thorough. Margaret called it obsessive during their monthly dinners, but the criticism felt distant then, professional rather than personal. Sarah created binders organized by year and case type, stored them in her apartment on industrial shelving she'd assembled herself. She worked intake and research, rarely saw the inside of a courtroom. At night, she reviewed closed cases, cross-checking digital records against the photographs she'd taken before files were archived. Most matched perfectly. Some did not. In February 2021, she found a discrepancy in a vehicular manslaughter case, a witness statement that read one way in her photograph and another way in the digital record. The change was small. 2 words. Didn't see clearly had become saw clearly. The conviction had hinged on that clarity. Sarah photographed the original statement again, made 3 backup copies, and wrote a memo to her supervising attorney. He told her the digital system was secure, that migration errors happened, that she should focus on active cases. She filed the memo anyway and kept looking. By June, she had found 11 more discrepancies. By September, 27. All involved witness statements. All had been changed after digitization. All involved the same prosecutor, David Reeves. She brought the evidence to her next case review meeting. Photographs laid out in careful sequence, a spreadsheet showing the pattern. Her supervising attorney listened, nodded, and suggested she present her findings at the next judicial conference. Margaret Chen attended that conference. She did not tell her daughter she was coming. The courtroom was not full, but it was not empty either. A dozen attorneys, 2 clerks, Judge Thornton presiding over what was meant to be a routine procedural hearing. Sarah stood at the defense table with her binder open, explaining how digital records could be altered retroactively, how her photographs proved 27 cases contained edited witness statements, how all 27 pointed to systematic evidence tampering. Her voice was steady. Her hands did not shake. She had practiced this presentation for 2 weeks, anticipated every question, prepared every exhibit. She did not anticipate her mother rising from the gallery, heels clicking on marble, voice cutting through the courtroom with surgical precision. Your Honor, I apologize for interrupting, but I must speak. Margaret Chin stood in her tailored charcoal suit, a partner at Whitmore and Associates for 16 years, architect of 3 landmark corporate mergers, a woman whose annual salary of $340,000 bought deference in most rooms. This room was no exception. Judge Thornton paused, gestured for Margaret to continue. This is my daughter, Margaret said, and the courtroom understood immediately that what followed would not be praise. And she's a total disgrace, wasting the court's time on closed cases like some paranoid hoarder. Sarah's breath caught. She did not turn around. She photographs everything obsessively, Margaret continued, her voice calm and clinical, a diagnosis delivered without malice. Her apartment looks like a conspiracy theorist's basement. She needs psychiatric evaluation, not a law license. Your Honor, our digital systems are secure. This is embarrassment, not evidence. Judge Thornton looked at Sarah, then at the photographs spread across the defense table, then at Margaret standing in the gallery with absolute certainty radiating from her posture. The judge's decision took 4 seconds. Miss Chen, our digital systems are secure. Your extensive documentation is noted, but unnecessary. Motion denied. The gavel fell. Margaret returned to her seat. Sarah gathered her photographs with hands that had finally begun to tremble, and the courtroom emptied around her like water draining from a basin. Her supervising attorney reassigned her that afternoon, intake duty, basement office, no courtroom appearances until further notice. The legal blog published the story within 3 hours. Junior defender's paranoia wastes court resources. Margaret forwarded the article to their entire extended family with no message attached. Sarah's younger sister stopped returning her calls. David Reeves, the prosecutor whose pattern Sarah had documented, the basement office sent her a brief email that night, better luck lit by fluorescent tubes that hummed in a frequency. She carried her camera and her binders down to the basement metal shelving lined where intake files were processed with cardboard file boxes and scheduled for digitization within and she did not stop photographing. Most attorneys would have considered this exile, punishment disguised as reassignment. Sarah saw something different. She saw 15 years of physical case files awaiting destruction, records dating back to 2008 before the courthouse had upgraded to its current digital system. She saw Thomas Wade's final warning made manifest, when they digitize, they edit. Always keep the original. For 6 months, she worked her assigned intake duties, logging new cases, scanning documents, answering phones. Then, every afternoon from 3 until 9, she began a systematic review of every file scheduled for disposal. She photographed 42 pages per hour, maintained temperature control at 65 degrees and 40% humidity, used archival quality labels on fireproof storage containers. She cross-referenced each photographed page against the current digital record, building a spreadsheet that tracked case numbers, dates, prosecutors, judges, discrepancies. The work was mechanical, exhausting, invisible. Nobody came to the basement except to drop off more files for destruction. Nobody asked what she was doing. Nobody cared. She reviewed 3,200 cases over 14 months. She found 127 discrepancies. 89 involved the same prosecutor. All had been edited during overnight hours after digitization. All favored conviction. The courthouse above her hummed with different work. Margaret Chen's firm celebrated a major contract in March 2022, $340,000 to implement Secure Justice, a new statewide digital evidence management system that would eliminate physical storage requirements across 23 county courthouses. Margaret became the public face of the initiative, gave interviews to legal journals, spoke at conferences about modernization and efficiency. At a state bar dinner in June, she used her daughter as a cautionary tale, though she did not mention Sarah by name. I know an attorney who chose paranoia over partnership, Margaret told 200 listeners over salmon and white wine. Now she's in a basement photographing garbage while the profession moves forward without her. The audience laughed politely. The speech was quoted in the state legal newsletter. Sarah read it on her phone during a lunch break, ate her sandwich, and returned to photographing file number 2418. She found Thomas Wade's old case files in September. They were buried in boxes marked for immediate destruction, 13 years of his work condensed into 4 cardboard containers. His handwriting filled the margins, notes, questions, arrows connecting disparate facts. At the bottom of the last box, folded inside a manila envelope, she found a handwritten memo dated 3 weeks before his death. They got to the files. Digital records don't match. Find the originals before they're gone. Beneath that, a list of 15 case numbers. Sarah checked her spreadsheet. All 15 were in her discrepancy column. All 15 involved David Reeves. Wade had been investigating the same pattern, had died before he could prove it. Sarah made 7 copies of his memo, stored them in separate locations, and added his case numbers to her evidence package. The Secure Justice platform launched in October 2023 with a courthouse gala. Margaret cut a ribbon. The governor gave remarks about transparency and progress. The system promised unhackable security, permanent digital preservation, and the elimination of physical storage costs. During the demonstration, Sarah sat in her basement office and watched the live stream on her laptop. She saw the interface, noted how authorized users could make retroactive corrections to records with no audit trail for changes made before the system launch date. She wrote a detailed email to courthouse IT outlining her concerns, sent copies to 3 supervisors. The IT director forwarded her email to Margaret with a note, "More paranoia from your daughter." Margaret did not reply. 2 weeks later, the courthouse scheduled all remaining physical files for destruction. The shredding would begin October 15th. The Secure Justice migration would complete October 13th. Sarah filed a motion to reopen 43 cases on October 12th, attached her complete evidence package, 847 pages of photographs, spreadsheets, and analysis documenting systematic tampering spanning 13 years. The courthouse threw a celebration dinner October 12th. Margaret gave the keynote address. "We're finally free from the burden of paper," she said. The audience applauded. In the basement, Sarah backed up her evidence to 3 separate hard drives, uploaded encrypted copies to secure cloud storage, and sent redundant packages to 3 trusted public defenders in different jurisdictions. At 2:47 on the morning of October 13th, she received an automated email, "System maintenance in progress." The Secure Justice platform went dark for 6 hours. When it came back online, 14,847 case files had been corrupted or permanently deleted. The disaster had begun. The database corruption occurred during an automated migration script that was supposed to consolidate records across 23 county systems into a single secure repository. Instead, the script encountered a conflict in the timestamp metadata, attempted to reconcile 40% of all files by overwriting them with blank templates, and then synced those blank templates across every backup system simultaneously. Recovery was impossible. The data had not been corrupted, it had been overwritten and then erased. By 6 in the morning, the IT director had convened an emergency meeting in the main courthouse conference room. By 7, the state attorney general's office had been notified. By 8, federal investigators were en route. Margaret Chin arrived at 9, her face the color of paper, to discover that the backup systems had failed because they were not backups at all, they were mirrors, synced in real time to the primary database, designed to provide redundancy against hardware failure but utterly useless against data corruption. And the physical files that might have saved everything had been shredded the previous afternoon, right on schedule, 18 hours before the system collapsed. The courthouse had no physical backups. Active cases could not proceed without evidence records. Appeals were frozen, no transcripts, no exhibits, no verification that convictions had been legitimate. Defense attorneys arrived to discover their clients' case files had vanished. Prosecutors could not prove the cases they had won. Margaret sat in the conference room
men on
as the
death
scope
row
of the
had
disaster
execution
became
dates
clear.
within 90
as
days,
attorneys and
and the
IT
state
staff
could
and
no
judges
longer
spoke in
verify
urgent,
what crimes
overlapping
they had been
voices
convicted of
about
committing.
liability and malpractice and constitutional violations. Her firm had promised an unhackable system. She had personally advocated for eliminating physical storage to save money, $340,000 in storage costs, she had told the board, money that could be reallocated to legal aid programs. The savings now looked catastrophic. Secure justice had been efficient. It had been modern. It had been a single point of failure wrapped in a suit of promised invincibility. By noon, Margaret's firm had placed her on administrative leave. By 3 in the afternoon, news crews had assembled outside the courthouse. By 6, the governor was demanding answers. In her basement office, Sarah Chin made coffee in her small percolator and reviewed the archive she had spent 20 months building. 3 filing cabinets. 3 backup hard drives. Cloud storage. Physical prints in a fireproof safe. Every photograph labeled, every discrepancy documented, every cross-reference verified. She heard the chaos upstairs, running footsteps, raised voices, the particular sound of institutional panic. She drank her coffee. She opened her spreadsheet. She checked her backups. All functional. All intact. All waiting. The professional world above her had built its house on sand because sand was easier than stone. Now the tide had come, and only one person had thought to carry stones. The disaster unfolded in measurable increments. Hour 1, IT realized the backup systems were corrupted too. Hour 4, the state attorney general opened a formal investigation. Hour 8, federal authorities took control of the courthouse network. Hour 12, Margaret's firm released a statement expressing concern and cooperation. Hour 16, the first wrongfully convicted person's attorney filed an emergency motion. Without case records, the state could not verify the legitimacy of her client's conviction. By midnight, 6 such motions had been filed. By dawn, 200. The death toll was metaphorical but no less real, 43 potentially wrongful convictions now impossible to verify or appeal, 6 executions scheduled for men whose case files no longer existed, thousands of victims unable to access their own case information, public trust in the justice system collapsing in real time. News footage showed an elderly man weeping on the courthouse steps because he could not prove he had paid his fine and faced rearrest for a debt the state could no longer document. A mother held a photograph of her son, imprisoned for 8 years on a conviction that had vanished from every government database. A defense attorney with a client facing execution in 30 days held a blank folder where 800 pages of evidence should have been. Judge Rebecca Thornton spent the day reviewing emergency motions, trying to construct order from chaos, and sometime near 7 in the evening she remembered a presentation from 18 months prior, a junior defender with photographs, a systematic documentation of evidence tampering, a mother standing up to call her daughter a disgrace. Thornton pulled the old motion from the court record, saw Sarah Chen's name, checked the office assignments, and walked down to the basement for the first time in her 12 years on the bench. She found Sarah at her desk, organizing photographs into evidence sleeves, surrounded by filing cabinets and backup drives and the systematic architecture of memory. Judge Thornton stood in the doorway for a long moment, looking at the archive, at the cross-referenced spreadsheets taped to the walls, at the young woman who had been exiled for refusing to forget. "Miss Chen," she said quietly. "Do you still have those backups?" Sarah looked up. Slid her evidence binder across the desk. "I have 3,200 cases. Including the 43 you need most." Judge Thornton's hand trembled as she opened the binder. The emergency judicial conference convened at 11:30 that night in the main courthouse chamber. 23 judges and attorneys assembled under fluorescent lights that made everyone look ill. Sarah carried her laptop and 3 external hard drives up from the basement, set them on the defense table, and connected to the courtroom projector without ceremony. She opened her archive, a database she had built in Microsoft Access because it was stable and offline and could not be corrupted by network failures, and displayed the first case file. Death row case number 4782. The defendant's name had been redacted per protocol, but the case was familiar to everyone present. The conviction had been national news. The execution was scheduled for December 3rd. The state's case file no longer existed. Sarah's backup was perfect. She projected the original witness statement, photographed before digitization. I was approximately 40 feet from the vehicle. Lighting was poor. I didn't see the defendant clearly. Then she displayed the digital version, a screenshot she had captured before the system collapse. I was approximately 40 feet from the vehicle. Lighting was poor. I clearly saw the defendant. 2 words changed. A man's life balanced on the difference between uncertainty and certainty. The room went silent. Sarah advanced to the next file. Then the next. Then the next. Each one showed the same pattern, original documents photographed before digitization, digital versions with subtle alterations, timestamps showing the changes had been made during overnight hours when the courthouse was empty. All changes made by the same user ID. All favoring conviction. All attributable to David Reeves. She presented 43 cases over 3 hours. For each one, she provided the original document, the altered digital version, the timestamp of the change, and a brief summary of how the alteration had affected the conviction. She also provided 3,157 cases with no discrepancies, proving that the legitimate convictions were supported by her documentation. Her voice never wavered. Her hands were steady. She had spent 20 months preparing for a presentation nobody thought would matter, and now it was the only thing that did matter. At 2:20 in the morning, a senior judge stood and spoke for the room. You saved these people's lives. You saved the justice system. Margaret Chin sat in the back row, watching her daughter present with the precision and competence that had always been there, that Margaret had dismissed as obsession when it was actually devotion. She did not speak. She did not leave. She watched her daughter become the person Margaret had tried to prevent her from being, someone who prioritized memory over ambition, preservation over efficiency, justice over career. At 2:33, federal marshals were dispatched to David Reeves's home. He was arrested in his bathrobe, charged with evidence tampering, obstruction of justice, and conspiracy. By dawn, Sarah's evidence had secured the immediate release of 6 death row inmates and opened investigations into 37 additional cases. The rescue had become a revolution, and it had happened because one person refused to forget. The exonerations began within 72 hours. James Sullivan walked out of prison first, 12 years of his life taken by an altered witness statement, his freedom restored by a photograph a young attorney had taken while sitting alone in a basement. News crews captured him on the courthouse steps, thanking the woman who remembered when the system forgot. His attorney held up the photograph that had saved him, a witness statement saying, "I could not identify the suspect with certainty," changed in the digital record to "I identified the suspect with certainty." The difference had seemed small until it meant everything. Over the next week, 37 more prisoners were released. 89 cases were sent for reinvestigation. David Reeves was held without bail pending trial. And Sarah's basement office became the command center for the entire recovery operation, federal investigators setting up workstations around her filing cabinets, her documentation system becoming the template for verification, her methods taught to 40 courthouse clerks who would spend the next 6 months rebuilding what had been lost. A reporter asked James Sullivan what to call Sarah, whether there was a phrase that captured what she had done. He paused on the courthouse steps, thinking about the woman who had saved his life by refusing to stop caring about closed cases. In court, he said slowly, someone called her a total disgrace for caring about old cases. But she's not a disgrace. She's a total disgrace. She photographs disgrace so justice survives. She sees injustice and saves the proof. The phrase went viral within hours, became a rallying cry for court reform advocates, appeared on t-shirts and coffee mugs and the letterhead of the National Legal Documentation Association. A disgrace transformed into honor through the simple act of remembering. Within 2 weeks, Sarah was appointed Special Federal Advisor on Court Documentation Systems, the youngest person ever to hold the position at 28 years old. Her salary was $180,000, still less than her mother's $340,000, but Margaret was now unemployed, her firm dissolved in malpractice lawsuits, her reputation destroyed by the efficiency she had championed. Sarah was asked to testify before Congress. She was interviewed by legal journals and national news. She declined corporate offers, including one for $400,000 from a firm that wanted her to design their archival systems. She stayed in the same courthouse, accepted a windowed office on the 3rd floor, but kept her basement workspace as Archive 0, a museum of the documentation that had saved 43 lives. On November 3rd, Sarah gave her first public testimony before a congressional subcommittee on judicial reform. Margaret attended, sitting in the gallery in the same seat where she had condemned her daughter 18 months before. After the testimony, she approached Sarah in the hallway while news cameras recorded the moment. "I was wrong," Margaret said, her voice stripped of its former certainty. "I called you a disgrace for doing the one thing that mattered, remembering. You were right. I was arrogant." She paused, gathering herself. "I made $340,000 destroying what you spent $28,000 preserving. Your way saved 43 lives. My way nearly killed them. Will you teach me your protocols? I want to help fix what I broke." Sarah looked at her mother, diminished, humbled, sincere, and nodded. "Yes, Mom. But first, you have to learn why remembering matters more than looking efficient." Margaret picked up a camera for the first time in her legal career, and they began the work of rebuilding together. If you found value in this story of justice preserved through simple persistence, I'd be grateful if you'd subscribe to this channel. These stories take significant research and time to craft, and your support helps me continue bringing forgotten vindications to light. Thank you for listening, and for caring about the truth that survives when someone refuses to forget. The transformation of the American justice system occurred in measurable stages over the following year. By October 2024, all 23 affected courthouses had implemented what became known as the Chen Protocol, mandatory physical backups stored in climate-controlled documentation centers, air-gapped digital systems that could not be corrupted by network failures, and independent audit trails for any changes made to case records. Architecture changed too. Documentation centers were no longer hidden in basements but built prominently into courthouse design, their importance acknowledged rather than concealed. Every entrance bore an engraved inscription, "Justice requires humility." Law schools began teaching Sarah's methods as standard practice: photograph everything, cross-reference systematically, assume that systems will fail and prepare accordingly. 89 law schools across the country added courses in legal documentation and evidence preservation. First-year students learned Wade's principle as foundational text: "The system forgets. You must remember." The phrase, "She's a total disgrace," became the official motto of the National Legal Documentation Association, appeared on merchandise whose proceeds funded wrongful conviction exonerations, and transformed into a symbol worn by defense attorneys nationwide. Small camera pins that signified vigilant justice. Annual Disgrace Awards honored individuals who exposed system failures through documentation. The first award went posthumously to Thomas Wade, accepted by Sarah on his behalf. The mockery had become honor, the insult had become identity, and the transformation was complete. Sarah's methods spread beyond American borders. 47 states adopted variants of the Chen Protocol within 18 months. International courts reached out. Canada, the United Kingdom, Australia implemented similar systems. The United Nations documented her methods for war crimes tribunals, where the preservation of evidence could mean the difference between justice and impunity for genocide. Sarah traveled, taught, consulted, but she refused to leave public defense work. She stayed in the same courthouse, still photographed every document that crossed her desk, still spent 1 day per week doing intake work because, she said, it kept her grounded. She kept Archive 0 as a working museum, brought new defenders down to see where the system had been saved, showed them Thomas Wade's photograph and told them his story. Sarah married James Sullivan. His heart attack, the first prisoner her evidence had explained, was the cost of fighting during his exoneration paperwork. Sarah had vindicated his fight, through shared understanding of what it meant when given his death failed by when they were his work. They had 2 children, taught them to remember what matters, brought them to Archive 0 to see the filing cabinets and the camera that had saved their father's life. Sarah mentored 200 attorneys through the Memory Project, a non-profit she founded to train defenders in systematic documentation. Margaret worked with her 3 days per week, their relationship rebuilt through shared mission, the arrogance replaced by humility, the efficiency replaced by thoroughness. At 62, the same age Margaret had been during the trial, Sarah's heart stopped while reviewing a case file in her office. She died doing what she loved, what she had been mocked for, what had saved 43 lives and transformed a nation's approach to justice. She died remembering. Her funeral filled the federal courthouse in December 2057. The 43 original exonerees, now elderly, served as pallbearers. Margaret, 96 years old, spoke with the clarity of someone who had spent 3 decades understanding what she had tried to destroy. "My daughter taught me that pride is fragile but truth is permanent," she said. "I called her a disgrace. She became justice itself." James Sullivan read from Sarah's diary, a passage she had written in the basement during her exile. "Justice doesn't need everyone to believe. Just someone to remember." The courthouse district was officially renamed the Chen Documentation District. Streets were changed: Wade Memorial Drive, Sullivan Justice Plaza. Archive 0 became a national monument, Sarah's original filing cabinet and camera displayed under museum glass, school children visiting to learn her story through interactive exhibits where they photographed mock case files and learned cross-referencing. The permanent inscription read, "She photographed what others discarded." 43 lives were saved by someone who refused to forget. Every October 13th became Documentation Day, a federal holiday in the legal profession when attorneys spent the day reviewing old cases, testing new protocols, honoring the memory of systems that had failed and the person who had prepared for that failure. The Chen Award was given annually to whoever had exposed a system failure through documentation. Sarah's methods became baseline assumption, redundancy valued over efficiency, memory prized over speed. By 2057, wrongful conviction rates had decreased 76% since 2023, and 4,847 convictions had been overturned using documentation methods Sarah had pioneered. Her grandchildren became attorneys, archivists, reformers. Her legacy became the foundation on which justice stood. The final image returns to where it began, November 2023, Margaret Chen standing in a courtroom saying she's a total disgrace, unaware that her daughter had just saved 43 lives through the careful work of remembering what others had chosen to forget. Judge Thornton about to lean forward and say, "Actually, counselor, your daughter may have just saved the justice system. Please sit down." The camera Sarah held that day now rests in a museum. The photographs she took now form the foundation of justice. The mother who valued efficiency learned from the daughter who valued memory. The system that prized speed learned to prize truth. And in a basement office that became a monument, in filing cabinets that became artifacts, in photographs that became proof, one principle remained: systems fail, memories fade, but evidence preserved by someone who cares enough to remember can save lives that everyone else has forgotten. The photograph fades, but what it captured, the moment someone chose to remember, never will.